Now we're going to look at the Bill of Rights, in particular, the first 10 amendments of the US Constitution. And in order to really understand the Bill of Rights, we have to understand the idea of negative versus positive liberties. So the idea of the Bill of Rights is that it's a set of limitations on governmental power. Those are negative liberties. They are things that the government cannot do against you or to limit your freedom. That's as opposed to positive liberties. Some constitutions in the country, in other countries, have positive liberties written into them, and they would be things like the government is required to provide you with housing, for example, or health care, or sanitation, or something like that. Those would be positive liberties, things the government has to do for you. But the Bill of Rights is framed in terms of negative liberties, things that the government can't do against you. So let's look at these principles. First of all, you should understand that as drafted, they apply only to the federal government. But through the 14th Amendment's Due Process Clause, the 14th Amendment was adopted after the Civil War, and the idea is that it was meant to require that state governments also follow the principles contained in the Bill of Rights. So generally speaking, most of the rights that are in the Bill of Rights are interpreted to apply to the states as well. So let's look at the First Amendment of the US Constitution, which is freedom of religion to begin with, and freedom of speech, which we'll talk about in a minute. So with regard to freedom of religion, the idea is that the government cannot establish a religion by favoring one religious belief over another or one church over another. And related to that, the government also can't pass laws or create enactments that would somehow interfere with people's free exercise of their religious beliefs. Now, those two provisions are sometimes in tension with each other because if you want the government to allow a full flowering of religion, sometimes that seems to shade into the government actually establishing or favoring a religion, but the idea of the amendment is no single governmental thumb on the scale in favor of religion, but also no government infringement on the right of people to freely exercise their own beliefs. And then, of course, there's freedom of speech, making some noise. So freedom of speech, the idea is that the government can't put a stop to the kinds of speech that you can produce in the public square, whether that's actual vocal speech or whether it's written speech. And in general, we say Congress shall make no law abridging freedom of speech. That's what the Constitution says in the First Amendment. But in reality, we actually do allow exceptions. So there's exceptions for incitement. So if I say to a crowd of people, go right now and kill that person who's standing right there, that would be inciting them. And if they then go and kill that person, that I could be prosecuted for, even though it was just speech. Similarly, defamatory statements. So if I say something false about somebody else to somebody else, and I do that with a degree of malice, and they are harmed by something that I say, then that would be defamatory speech. As we will see in a later unit, intellectual property law also prohibits speech. So for example, if you're violating someone's copyright, it may be that you're speaking, but you're speaking using someone else's material, and so that also can be legally proscribed. And then commercial speech, very important for the business law arena. Corporations and businesses actually have First Amendment rights, and so the government can't simply regulate commercial speech at will, but it's a lesser First Amendment protection, and in particular the government can regulate misleading speech. This particularly comes up with regard to things like false advertising. So false advertising, of course, is speech, but it's allowed to be regulated because it's commercial speech and gets a lower level of constitutional protection. The other very important distinction I think we have to make with regard to free speech is the difference between content-based and content-neutral regulations of speech. Here, the idea is if the government is regulating speech based on the viewpoint being expressed or the particular type of content, like will allow speech by this political party but not that political party in the town square, that's core First Amendment content-based regulation that will be proscribed. But you could imagine in that same town square, the government could enact a rule that says you can only hold rallies between the hours of 9 a.m. to 9 p.m. Because they don't want people holding rallies at midnight and keeping the neighbors awake. That's what's called a content-neutral regulation of speech. It's also sometimes referred to as a time, place, and manner regulation, meaning that the regulation is not geared to who the speaker is, it's not geared to what they're speaking about, it's only geared to the time, place, and manner of the speech. When it might happen, how you might have to apply for a permit, things like that. And as long as that's done in a content-neutral way, generally speaking, that'll be allowed. What about the press? Here's a little picture of a press conference. Freedom of the press is also protected under the First Amendment, and in particular, U.S. libel law is extremely forgiving of the press, so that even if something is in a newspaper article that turns out to be false, if it's about a public figure, the press gets a tremendous amount of leeway unless they operated in reckless disregard of whether the information was true or false. So U.S. libel law is very, very narrow. It's hard to win a libel suit, particularly if you are a public figure. And that's in part because we want to support the idea of freedom of the press. Fifth Amendment, due process of law. That's a pretty vague phrase. We talk about whether you received due process. The Constitution does not make it clear what due process means. We've had many, many Supreme Court cases over the years that deal with issues of due process and what procedure is due. We're not going to go into the details of that. You just need to know that the Fifth Amendment does, in fact, regulate government with regard to due process of law. And then there's also the takings clause of the Fifth Amendment, and the takings clause says that the federal government cannot take your property away from you without providing just compensation. Now, how would they take your property away? Well, they might say, we need your land because we need to put a railroad through your land, and that would be a taking, and they would have to provide just compensation for that. There's also a concept of regulatory takings. Maybe you own waterfront property and a new regulation comes in that says nobody can go in the water because we're trying to preserve the environmental purity of the land or something like that. No one can go in this body of water anymore. And suddenly, if you were a hotel with property right by the water, you might find that the value of your hotel has gone way down because now your customers can't go in the water. That would be known as a regulatory taking. And if a court decided that the regulation was so severe and so impacted your economic value, it might say that it was a violation of the Takings Clause unless the government provided just compensation. So that's the idea behind the Takings Clause. And finally, we're going to talk a little bit about the 14th Amendment. I mentioned it earlier. It was enacted after the Civil War, and it was designed in part to make sure states followed provisions of the Bill of Rights. But in addition, there's a very important equal protection clause within the 14th Amendment. Obviously, the Civil War was, at least in part, about slavery. So after the Civil War was fought, this is one of the amendments that was enacted to try to make sure that people were given equal protection of the law, and particularly with regard to African Americans. And so as the 14th Amendment jurisprudence has developed, the idea is that we will always give heightened scrutiny to any law that limits either a fundamental right, like freedom of religion or something like that, or that employs what's called a suspect classification. So if there's a differentiation in the law based on race or religion or gender or national origin, we're going to give that law extra scrutiny. Now maybe the government can provide sufficient justification for that law to get over the heightened scrutiny, but it's hard. So generally speaking, if there's one of those suspect classifications, or if it's a law that infringes on a fundamental right, it's going to get extra scrutiny from the courts. All other laws are given what's called rational basis scrutiny. And so the idea is that generally speaking, if Congress or a state legislature passes just a general economic regulation that regulates commercial activity and doesn't make any of these invidious distinctions based on race, religion, gender, or national origin, we will only give rational basis scrutiny to that law, which means usually it will be upheld as long as there's a governmental interest that's articulated and the law is a rational means to get there. So that's the idea behind the Due Process Clause of the 14th Amendment. We have both an equal protection component and, as I said earlier, the due process component is just applying the Bill of Rights provisions to the state governments as well as the federal government. So those are the basic provisions of the Bill of Rights that I think you need to know that would be relevant to business activity. Obviously, there are other rights that are articulated in the Bill of Rights, but those are the ones I think that are the core ones that you need to know. And again, watch this video a number of times, look at the other materials so that you feel comfortable with these rights provisions.